Good afternoon, everyone. I, Shashank, on behalf of NEN and Vabhani Foundation, would like to invite you all for this webinar and also introduce our expert. Mr. Deepak Kumar Khaitan is the chairman of Eastern India Regional Council of the Institute of Company Secretaries of India. He is a fellow member of ICSI and holds a master's degree in commerce from University of Calcutta. Deepak is a certified mentor from London Business School, Goldman Sachs and National Entrepreneurship Network. He has also been a faculty of law and entrepreneurship in St. Xavier's College, Sri Shikshayatan College, J.D. Birla Institute, and has been invited as a resource person by various institutions from time to time like IIM Calcutta, IIM Indore, IIM Lucknow, IIT Bombay and so on. Before I hand over the floor to Deepak, here are a few reminders for the audience. You will all be on mute. You may ask a question by typing in the panel provided. Over to you, Deepak.
Okay, good afternoon, everybody. I hope we are all fresh startups, and as the theme goes, key legal and regulatory proceedings for procedures for starting up in India. My suggestion would be that from my experience, I have jotted down some common questions which young entrepreneurs and startups have. In case you have other questions which are not being answered here, please just jot them down and put them on to Shashank, and then we can have a Q&A at the end. To begin with, I would put the first question which generally everybody has, as you can see in the slide. Should I make a private company or a public limited company, and which one is better for me? For this question, friends, it's a very simple criteria that private means something which will remain within you, and public would mean which will go out of you and have extended arms. So in case you have no intention as of now to raise money from public at large, to go for listing, to collect money from a large number of investors, and in that scenario, you should always start with a small company, a private limited company, and in the new regime of Companies Act 2013, which has just been passed, you also have something called one-person company. So a single person can start his own company without having two people, and all these formats which you choose, you have options in future to convert them into a public limited company. So starting up itself with a public limited company, to me, doesn't make a sense. We should always start with a small type of an entity and expand as and when required. I would move on to the next question, which deals with the concept of limited liability partnership. If we have been recently seeing the changes in corporate India, you will find that LLP, that is limited liability partnership, has emerged as a new form of business very recently, wherein you can create a very good combination between partnership as well as a private limited company or a company, and there the liability of the partners become limited. Why I say so is, like say for example, those of some of you who are into partnerships of one form or the other in your business model, you will find that the partners have, one partner A is responsible for the liabilities of another partner B, and in a LLP, this liability again becomes limited, and a partner is not responsible for certain acts of another partner. It's a very, very new form of business, comparatively very cost effective, and that is how this LLP has gained momentum. In overseas, LLP is quite common form of business. In India now, since we also have got LLP, we also have got a one-person company called OPC under the new act. So these new forms will help entrepreneurs, get into a corporate lifestyle or a corporate structure for business purpose. By lifestyle, I mean corporate structure for business purpose very soon. So rather than being a proprietor, you can start up these forms. I will always suggest an LLP over any other form, and in case you choose a company, I will always suggest a private limited company or a one-person company. And thereafter, when your time comes, you can always expand to a public limited company. The next question, friends, which most young entrepreneurs would know and would require to know is, about contracts and agreements, because that is one thing which most of you would be entering on a day-to-day basis. But for that, we always have to run to a legal help. But there are some basic things. Those who have done commerce as a graduation, if you go back to your college days, you remember one line saying about agreement and contract, that all contracts are agreements, but all agreements are not contracts. And that comes very handy when the moment you go into your corporate workings, because ultimately you are entering into an agreement, putting them in a piece of paper, things only so that if you have a problem tomorrow, you can refer to that and get into a solution. But what will happen if your document which you are relying on for future is considered as unenforceable? So this means that suppose you enter into a contract with anybody and the other fellow doesn't perform, and tomorrow you want to get some compensation for him or make him perform. Every time we don't look for a compensation because that doesn't suit our purpose. So if you want to make him perform, then how do you do that? And you request him, and still if he doesn't agree, what do? You take him to a court of law. There, if it is held that fine, there you are bringing an agreement before me, but this agreement is not enforceable. So this means that there is something missing in this agreement, by virtue of which the relief which you want to claim over the other fellow, that relief will not be available to you. So in that point of time, the whole process which you've got into, that piece of paper, looks a very useless document. And that is what happens most of the time. So any document which you, in your local understanding, which you want to refer to as an agreement, right? Please make sure that that agreement has all valid features of an agreement, and that is also a contract in that sense that it should be enforceable. So when you make a document or when you go to a legal person to have that document done, right, you must raise a question on the enforceability of that document, because that is the time when you will actually require to use that document, when the deliverable of the other party is not coming in place. So that is one very important thing which we miss out, and once we miss that out, our claim on the other fellow becomes negligible, and this process doesn't make any sense. Now somebody may ask me, what are those features which are very much necessary for an agreement to be known as contract? If you open the books, and even if you don't open that, I will guide you. You will find there are certain essential elements of any valid contract, like say for example, like legality of the subject matter, the object of the subject matter, the consideration, right? So if you want to say that I'm paying you 50,000, cash, which I'm not accounting in the book, and that, on that strength, if you want to enforce a contract, then that will not be considered as a contract. So this means consideration has to be legal, consideration has to be adequate, right? And then of course there are many other things which are all legal understandings. There has to be an offer, there has to be an acceptance, there has to be a contract between parties who are competent to contract. A contract cannot be with a minor unless there are certain exceptions to that stake. So these are some very important points which we must be aware of. So I thought I will put this question as an agreement and a contract. What's the difference? Come to the next question, friends. At times we have to issue checks to vendors and suppliers, and at times the checks may be issued and they get bounced because there are not sufficient funds in the bank of the banking account of the company. What happens in that case? There is a section called 138 of the Negotiable Instruments Act, and if your check bounces because of insufficiency of funds, then in that scenario a lot of legal issues will come up. The fellow will first give you a notice. There will be a time period specified as per the law, and if you do not pay up, end up paying by that time, then that fellow has an option to sue you and recover the money from you, and it could end up as criminal proceedings also. So these days, gone is the era where you could issue a check and then it could be bounced, and that series could go on, right? Because people have grossly misused the liberty which was given in that format. And so now as of the current state stands, which is the very correct position also, that unless you have check a backup in the bank account, please do not issue the check, because if it gets bounced because of insufficiency of funds, then a new series of litigation would come upon any kind of an entrepreneur. Friends, this is something very interesting. At times when we borrow money from banks, we need to go and tell them that, they ask for security unless it's a specific project funding scenario. And in the security, they ask for the things, the assets which you can secure with them. This means a mortgage with them, and then other like things like shares which you can pledge with them. But this whole process of getting there as a create by way of putting your assets under some kind of an encumbrance, this whole process is known as creation of charge in legal terms, or a charge creation. It's a very interesting thing to know, friends, that there is something also called a floating charge, which many young entrepreneurs possibly miss out. And because at times banks may not encourage that also, but there is a provision for it. Like, say, what's a floating charge is, I'll first go to fixed charge so that you understand a floating charge comparatively easier. So suppose you have a land with you or a building with you, and you put that as a security to your banker, and then after, if you default, then the banker can claim upon that kind of a bank, that land or that building, to recover the dues. Similarly, if suppose you have stocks in your godown, if you have stocks in your showroom, right, and you can also then pledge those stocks with the bank and tell them that, see, on any given day in my shop I have goods worth rupees, say, 50,000. So this means I can jolly well borrow from you 25,000, because if I default, then you can always come and take back goods worth 50,000. So there are ways of creating a floating charge. Why I thought this would be important, because some kind of a cash flow and a working capital is always required by the startups, and this would help them in the floating by understanding a floating charge. Then, friends, comes another question, which is the commercial points while drawing a memorandum of association. Now, before that, because the topic has been little redesigned, it talks about the regulatory procedure also. Just let me brief to you the various regulatory authorities in the country, so that you have a brief snapshot of what lies ahead. So if you make a company, or if you make a LLP, then you are governed by directly for that purpose by Ministry of Corporate Affairs through the Registrar of Companies of the particular state. Almost every state has a Registrar of Companies in the country. If you make an LLP in the same format, you are governed by Ministry of Corporate Affairs through the Registrar of Companies. If you make up a proprietorship, friends, then there is no separate authority to govern you for that. Your returns would only be filed with the business returns, revenue, as far as income tax is concerned, that gets filed along with your return itself, because no separate entity has been created, so no separate regulatory body is available. If you make partnerships, societies, and all those formats, then there is the Registrar of Partnership and Firms and Societies. Now, most of these fall under the different state governments, so you would be monitored by the state government, respective ministries or departments, as the case may be. Now, if you make up a, if you then after become a listed kind of a company, then Securities and Exchange Board of India comes in the picture. Now, if you have only Indian money in your company as equity or any other share capital, then there is no question. But if you have any foreign equity investor, any foreign shareholder in your company, then the Reserve Bank of India comes into the picture. My point of dedicating this time to you on this topic was only to help you understand that more and more you expand and more opportunities you take care of, the number of regulatory authorities definitely increase, and that is on the positive side, because in today's scenario none of the regulatory authorities actually prohibit you. Certain compliances to be covered, and they are actually of a great help. So now when we talk of that memorandum of association of any company, we are talking of the body called a private company or a public company, and that talks of the registrar of companies, and there comes a document called Memorandum of Association. Now I have purposely not said what are the legal points to be addressed. I have said what are the commercial points, and in the commercial points, the main point comes is clause number 3. Now clause number 3 talks about the objects of the company. What happens is, out of my own experience, we have seen that many times entrepreneurs come to us and they say, please register a company for me, and we take all the details and we register the company, but they're not very clear. Like say, I'm not an IT person, so if somebody wants to come up and say, please make an IT company for me, then what do I write in the object clause? So I could write to design hardware, to make software, and so on, and other things. But even if I do all Google, I may be missing out something because it is not my core domain. So as entrepreneurs, the most important point for all of you is, while you tell anybody or you take your own exercise to register your company, please make sure that what exactly you want to do must be mentioned in the object clause of the memorandum. And this has to be gone in a little more care, because anything which you do which is not covered by your object clause is actually illegal and would land you up in trouble. So it is always better to express that more clearly rather than keeping it vague and keeping scope for any kind of interpretation by anybody. And it is also important, friends, to make sure that if you have, again, as I said, there is no bar, because you can do business anywhere in the world. But if you really want to do abroad, export, import, then it's always better to mention it in the memorandum itself, right? Like say, for example, to do business in India or elsewhere, of buying, trading, manufacturing, blah, blah, blah. So this is how you become more specific and expressed in your terms. At times we find that memorandum do not specifically cover what you actually want to do, and in that case two things happen. Either you do it and then keep everybody in dark and then keep that risk on your head running, or secondly, then you have to alter the memorandum. And these days even though nothing is impossible, but altering the memorandum has a little procedure to be complied with, which may not be good for you because of the timing, because anything which you want to take a decision has to be taken today or very shortly. And in any case, if by chance the procedure took a little longer time for you, then you have to wait for the approval. But even then that comes first. I would always suggest that we should have our document in order rather than changing it for our purposes. As I said earlier, the memorandum can always be changed to as per your requirements. So if you start up an IT company today, and you can always change that IT company into the say a hospitality company, and so on and so forth. Okay. Yes. The next question, friends, would come that what are the business points to be taken into consideration while you draw the articles of association of a company. Articles are, friends, like the constitution of the country. Just like the country has a constitution, it's the constitution of the company. It takes up the basic day-to-day board procedures, the general meeting procedures, the procedures of who has more rights in terms of organizing the affairs of the company, who has more issues, control in terms of the voting of the company, how will the decisions in the company be done, right? How the reimbursements will be paid, how the directors have to behave, how the auditors have to behave, and so on and so forth. So almost each and everything which could, actually come to your mind would be a part of the articles of association of the company. And in that scenario, the utmost care should be taken to draw the articles. At times, I have seen, people just copying the articles of any other organization and just trying to sail through that, which happens for most cases. But it's very dangerous because you have your own requirements, and unless those requirements are addressed and made a part of the articles of association of the company, you should have prescribed for yourself, and that lands you are in trouble. So please take care in addressing all your issues, voting issues, power. At the same time, in future, if there is any dispute between any of the partners means literally the shareholders of the company or the board of directors of the company, then it is this articles of association which would actually take a final call that who has done the correct thing, whether it is the group A or whether it is the group B. And this is how things have to be addressed. I could see one question which has come up, which says that can I change my LLP to a private company in the future? Answer is certainly yes, and it's entirely online, right? And you fill up the online forms, and the website is www.mca.gov.in. I just put that in, and once you upload these forms in the website, you will find that the conversion has taken place, and the registrar of companies has given you the necessary approvals. Okay. Now we come to the next question, which talks about, one second. Yeah. Can I bring in foreign investment in my company without government approval? Now these days, this is very much important. These days, this is very much important because the moment we do a little bit of expansion in the business, we try to get foreign equity investors in a company, and at times it may be for their instance also, because they may find the business lucrative, and they may put that offer to us that they would like to participate in our business. So and at times we might need money and we would like to rope them in. At times the idea sounds very good and they join us, and we have heard a lot about VCs and then private equity and all those things, but ultimately most of them come from the foreign investment channel. So as of now, friends, just to give you a small background, this whole thing is governed by Reserve Bank of India, and every year on the 1st July comes the master policy on FDI, foreign direct investment in the country. As of now, the entire country, the FDI policy permits almost everything under the automatic route, except certain sectors like defense and housing and so on and so forth. And in the automatic route, you need not wait for the government approval. So you bring in the money through the banking channels, and let the equity be allotted in your company, and you have to comply with the laws in terms of informing the authorities, and we call them as authorized dealers. And those authorized dealers are like the authorized by the Reserve Bank of India, who are nothing but your banker. So the bank in which the money has come in, that bank, that branch will act as the authorized dealer, and you submit. So within 30 days of you getting the money, you submit them the intimation that the money has come in for this purpose, and after 30 days of allotment, you make sure that you submit a form called FCGPR to them, and after that, you know, the this whole process, correct, has to be completed within 180 days time period. So if a foreign equity comes in my company under the automatic route and I don't make the shares allotted within 180 days, then in that case, the whether you want to refund the money, whether you want to allot the shares, now everything becomes a question of approval, which prior to that, if you are complying with the law, then there is no need of any approval. There is a need of confirmation. So no prior approval is required. So if to summarize, can you bring foreign investment in your company without government approval? Answer is yes. You only need to, there is post-compliance, post-investment compliance. There is no pre-issue, pre-investment compliance. So you need not wait for approval. You just make sure that you comply within the given timelines. The next important question, friends, is an issue called TDS, which is tax deducted at source. I have experienced in my life one very good entrepreneur who came all the way from US, started up a company here, but he knew nothing about TDS, and he did not appoint any auditor or accountant, to help him out, because he did appoint, but he never talked to them on these issues because he just didn't feel the need of it and he couldn't understand. And ultimately, friends, he paid a lot of money to a lot of people in due course of business without deducting TDS. And the income tax rules provided that if you do not deduct TDS, then that expense could be disallowed. So this means your profit, if you paid 100 rupees to somebody without deducting the TDS, then to that extent the profit could become higher. So that will not be considered as an expense at all. And you end up paying more taxes. And of course, there has been violation of all TDS related laws. So these are some very draconian laws which exist, which you need to take utmost care, because a small violation can create a lot of problems. Expenses could be disallowed, the fines and penalties could be higher. Similar issues lies with service tax to whomever these applies. So the point which I want to make is that just take a brief understanding of the tax structure before you actually start, or before you do something in a little advanced level, because any revenue model could get disturbed if the tax structure is not duly addressed, not only because of the tax component but also because of the cost of violation which comes later on. So I thought this would be very important for most of us, because we would not necessarily know, and if we know it already, it's very good. I see a question here which talks about job placement agency. I just can't understand that. If anybody can help me understand, the person who put in that question, job placement agency. So I'll get back to you again. Okay. The next question is, friends, which I thought is what I must know before entering a joint venture. Friends, joint venture is nothing but a partnership, and it's a sort of a partnership. It can be in any format. So say a JV company could be made, right? Now, the moment you are in a joint venture, it is very clear that you are not alone. So if you are not alone, so this means that you need to take care of the partner's requirements as well. And if you need to take care of the partner's requirement also, then there has to be a code of conduct for decision making between both of you, for the sharing things between both of you. And there is where in a company format the articles of association comes very handy, wherein it has to be clearly mentioned that what is the joint venture partner A looking at, what is the joint venture partner B looking at. Both their agreements have to become a part of the articles of association to make the company binding by those agreements. Thereafter, the JVs should not be falling under any other violation. Say for example, the Competition Commission of India is another authority. if you want to do something in the monopoly kind of a thing, you want to prevent competition, right? So those kind of things, pools, cartels, many times we enter into those kind of things. So those things will not be allowed, and they are not, because they are not legal in nature. So you cannot, you have to check, you make sure that your documents are not, your actions are not anti-competitive as well. Okay. Now, so many other points would come into question when you talk of entering a joint venture, like say, the question of the transaction, the deadlines, the exchange of considerations, the deliverables, who will give what to whom and when, the milestones to be achieved, right? The exit clause, that is the most important, which most people fill out, because if a JV does not have a respectable exit clause, like say if an achievement of certain milestone, one partner would like to go away. So if he is going away with his share of cake, then how does he go away? He sells the shares to the third party. So this means tomorrow you will be constrained to, join a sit on the board with a third party which you actually never wanted to, because you don't know him as such. So this means that there could be, exit clauses in the joint venture, which talk very carefully and deal with the issues. Like say, for example, a clause could be there that if there are two JV partners, A and B, and if A is willing to move out or exit due to certain issues, whether compliance or non-compliance, achievement or non-achievement, whatever, then B will have the first right to buy the shares from A, and A will have the first responsibility or an obligation to sell the shares to B. And if B refuses, then A can sell to anybody else, right? So I'm just giving you one example. So these are the kind of things which are very much important when you talk of a joint venture. Apart from that, since if it's a JV between companies incorporated or entities of two different countries, then the respective laws of the different countries must also be taken care. Which law would be referred to at the time of a dispute has to be very clearly decided by both the parties. Which are the courts you will refer to, that has to be decided. And in case we are not very firm on those things, then the complications would definitely keep on increasing. Next question, friends. A for Apple, we have all learned when we were school days, but in the legal world we learn, in the commercial world we learn A for arbitration. Because friends, in a commercial situation, it is bound that some kind of disputes, differences would definitely take place between two parties, whether it's a vendor or myself, or between two customers itself dealing with the product of the company, whatever. And in the kind of arbitrations, it may also at times happen when you default in your payment obligations or when you default with your banker. So all agreements which you are talking of, all situations, all transactions for that matter, where you have taken a deliverable, or you will be making some kind of taking some kind of a payment obligation for future, it is always suggested that please make sure there is an arbitration clause. In an arbitration clause, both sides would have right to select an arbitrator, and he would have their and if both cannot come to a common conclusion, then both can appoint one each, and then both of them can appoint the final one. And in that scenario, one ends up reaching a code of law, which is a much better option than at times to save cost, to save money. Sometimes international arbitrations can actually be very costly, but in general, I know small arbitrations are much quicker, much faster, and they give you much better relief in terms of timing, because in business the money which you recover is not that important, along with the if you ignore the point that when do you recover and how do you recover. So the timing, to me, timing is most important. Time saved for my business is much better thing to do, rather than and because it allows me to focus myself on the core business, because I don't want to become a litigation expert by dragging people to the court. So unless you have something specific damage to recover, and you are very certain that you will be able to recover those damages, I would always suggest to go for arbitration instead of litigation. Next question, friends, on the screen is affirmative rights. Now, what is this affirmative rights? Now, suppose, friends, there are two business partners, A and B, and in a company, and they are two shareholders in that company. They are two directors in that company. But B has come in only by bringing in the money, and A has all the know-how and the software and the technical decision-making capacity. B has come with the finance. But as of now, both have taken equal shareholding, or possibly A has taken a lesser equal shareholding and B has taken a more shareholding. Now, the question which comes is, if B, says that I have brought in money, so I will decide everything. If B says on certain issues, and A says that no, you brought in money, but you cannot decide on everything because you don't know those things. You know from where to get money, but you don't know how to make this product. I know that because I did this invention or whatever, research. Now, in that scenario, it's difficult because both of them are legal, correct decision makers in their own respective capacities. So comes the question of affirmative rights. So if the articles or your internal agreements, put on record that, come watch me in any circumstances, these decisions on these points A, B, C, D, say for example manufacturing, hiring, right, some of certain technicians, or etc., would always be taken by A, or it can be taken by B but in consultation with A. So this means that in that respect A has affirmative rights in the company. Similarly, if it comes to a question of finance, you can always say that at before any borrowing, the consent of B will be important, and without that the borrowing will not take place. Now that is a scenario where B has affirmative rights on that subject in the company. So the point is that in my own personal experience, I have seen people end up going into disputes and saying that they can do this, they can do that, but in the beginning and during the course of business, while they were apparently clear that you will deal in this line and I will deal in this line, but when it came to final remedies, they just forgot that, and that is where troubles started. So it is always better to freeze the affirmative decision makings right from the beginning and decide who will do what. You can ask me questions unless before I move on to the next. Sashank, are you there?
Yeah. Thank you, Mr. Deepak, for the presentation. We'll start with the question answer round. Before that, I just have a request.
Yeah.
Can you use your microphone, please, for this, because I have my voice is echoing and the audience are having a problem hearing this.
Okay, I am on my microphone. 1 second. I'll just use this. 1 second. I'm using a headphone now.
Okay.
Is it clear now?
Yeah. Thank you, Mr. Deepak. We'll begin with the question answer round now. There are a lot of questions, and the audience are eager for these questions to be answered. The first question is from Prashant. This was the one whom you were referring to in your presentation. Prashant has a startup in a job placement agency, and he wants to know how to get working capital funding for his startup.
1 second. The voice is very low.
Okay, I'll repeat. Prashant has a job placement agency as a startup, and he wants to know how to get a working capital funding for his startup.
Hello.
Am I audible,
Hello?
Mr. Deepak? Am I audible?
I just removed this because I can't listen to it. I can listen to now. Can you repeat the question, please?
Yeah, sure. Prashant has a job placement agency for a startup, He wants to know how to get a working capital funding for his venture.
Okay. See, job placement agency would necessarily involve, that you are referring. It's a referral kind of a business where you are referring somebody to hire somebody, and you have two kinds of basic revenue models. One is that you charge the people who are getting placed. Other is you charge the people to whom you are placing. In this kind of a scenario, the working capital is a little tough because it is actually a service-based industry. So he has to be very clear that what is the object of the use of that working capital, because no infrastructure is required in terms of setting up any plant or machinery or anything. So basically, it's marketing, advertising, and that developing that network. So once the objectives are very clear, in a service industry of these types, the working capital management can be done very easily. And now, if the objectives are not clear and we end up, creating big offices without understanding the use of that, there is where we end up in a cash flow problem. Could I give the answer?
Yeah, sure. The next question is from Saurabh Kumar. He wants to know what are the legal requirements for starting an e-commerce business in India.
See, for e-commerce business, apart from all what we have discussed now, one very important thing comes is the payment gateway. So you have to go to the banker and like say for example, you can go to ICICI or Axis or whatever bank, and like when we pay through the online credit card kind of a thing, that payment gateway is important. So once you are able to successfully put a payment gateway for yourself, you can take care of the e-commerce requirements. And while you put the payment gateway in place, your business becomes a little costlier because the banks have certain transaction charges which they recover from you. So if you give them volumes, you would be able to get some kind of a discounts. And if the transactions are very slow, then the e-commerce would be a little costly. Okay.
Yeah. The next one from Sachin Taneja. He asks, he has registered a two-person company. How can he convert it into a one-person company?
See, the one-person company has been defined under the Companies Act 2013. The two-person company is under Companies Act 1956. As of now, only 98 sections, including the subsections of 2013 Act has come into force. The rules are still being considered by the Ministry of Corporate Affairs. They are in the draft stage. To my personal understanding, in another 2-3 months' time, the new Companies Act along with the rules will be in place and it would be notified very soon. Once that is done, you will find specific forms which you can just fill up online, and then it can be that one person can exit, and then he can also exit by way of a complete share transfer, and it would be a very simple form at that point of time. You just wait for some more time for the government to come out with the details. You can convert that online itself. Just one question will be there before you convert. Before you convert into the two-person into a one-person, you have to make sure that all the filings of the two-person company are in order. So your balance sheet, annual return, all filings with the ROC is in order. It will be converted easily.
Pranjal Kumar has this next question for you. He wants to know how to form an advisory board and how should it be structured, and what are the difference between board of directors and an advisory board?
It's a very good question. In Indian scenario, we generally mix up both these situations, but in foreign organizations, we see two different boards. The board of directors is the legal set of directors of the company which are eligible under the Companies Act and the law of the land for the acts done by the board and for the decisions taken by the board and the company. The advisory board and they will devote much more time to the company, whether executive or non-executive. The advisory board would contain of people who are spread across much more domains and they have not much financial interest in this company in any case, and they are engaged otherwise, but out of your own conviction, and you have been able to convince them and take their help. So and you form an advisory board, but an advisory board has no legal recognition and no legal sanctity. It is as per the company's articles, and otherwise also it can always remain, and it can give advice to the board, but it has no legal mandate as such in the country as of now.
Rahul Banka has the next question coming up for you. He wants to know, will changing from LLP to private limited require him to change agreements with suppliers and customers?
Both the LLP and the private limited company will be under the same ministry. So technically the entity has changed, but the governing body remains same. So, and it will be a conversion. It will not be a closing of the LLP and making of a new entity. It will be conversion of LLP into company. So you can always, just inform your vendors and your other concerned people that your LLP has been converted into a company. So all those transactions which you undertake with them as LLP till that date, till the date of the conversion, would by default stand transferred, to the company's name. So there is no need of redoing everything. But if you want to do it, it is your choice. The law does not require you to redo everything.
Siddhartha Mohanty asks, in case of a startup or a private limited company, how do you decide or divide the equity stake among directors?
See, the directors may be of various types. If the directors are all, say A and B both are having the idea and both are equally competent to take care, then it is up to them that who will devote how much time, assuming that both are hell-bent to give equal amount of time and energy in the new startup, then both should get equal number of shares. But if there are very simple models that you take some criteria like the time to be spent in next 5 years, the time to be spent in next 10 years, and then the investment, who is spending how much, then the content, the technical know-how, knowledge, and then the responsibilities. This means the day-to-day liaising with the different departments, or the production, or the sales, or the marketing, and all those things once decided, you can take a call that which kind of a director should be getting what kind of a share. While answering, I am assuming that directors are the ultimate shareholders also, right? And in any case, we can also settle this issue by way of say if there are certain non-executive directors on the board who are not promoters, so they may not have any shares as such in the company. So these are some basic criteria which should decide that which director will have how much share. As of India, there is no compulsion that any director will have to have all certain amount of qualification shares. That kind of a law does not exist anymore. So one can be a director even without being without having any shares at all. If suppose he doesn't want to be a shareholder and he's only a professional director, so he can still be a director, except from the OPC type of a company, 1% type of a company.
Aparna Das asks you, Mr. Deepak, that a sole proprietorship firm is engaged in designing textiles or fabrics. Will this be a service under the law? When does it require to register for service tax registration?
See, service, to be very honest, there are many things, to my personal opinion, which are not service, but which has been considered by the government as service. For that, you will find there is the service tax, the Ministry of Finance has come, and the Central Board of Direct Taxes, they have come out with a negative list of items. So negative list means these are the items on which service tax are not attracted. Apart from that, on all items service tax are attracted. So I'm not very sure whether your article falls in the negative list or not, but it is very simple. You can just check up the negative list. If it is not there, then the service tax obligation is there. Number two, for different kind of entities, there are different kind of slabs available. So like say an individual is exempt up to rupees X. Body corporate is not exempt at all. So depending on your entity structure, you could just see the exemption list and take a final call. As of now, if by chance you have done any kind of a mistake with respect to service tax, then the schemes are on by the government wherein you can, pay voluntarily and close up the matter, because after that, they would not listen to and penalties would be imposed.
Raj Mishra has been working on a freelancing project, which is a kind of online tutoring.
Yeah.
The client used to pay in US dollars through PayPal. He wants to know how can he take care of tax issues.
A client is paying through US dollars.
Yeah, through PayPal.
See, there are two ways here. See, if he is rendering this service in India, so I'm assuming that he is rendering from India.
Yes.
So he is liable to pay tax in India. He is an SSC in India. Okay. And depending on the structure, whether the payment is coming in the individual's name or the payment is coming in the company's name, the tax rates will apply. Now, he has a choice at this stage to decide, whether he wants to receive in rupees or whether he wants to receive in dollars, and accordingly, he can officially go for hedging of the receivables as and when it takes place. Actually, this will be done by the other person who is paying him, but then he would be very sure on which date he is receiving whether dollars or rupees, and he can, book for a forward or a sale on those dates if the rates are okay on currency exchange for that particular date. So apart from that, I don't see any tax issues, because there is no separate, that on foreign earnings so much would be taxed. It is not in my knowledge. Now his entity would take the final call whether it is a body corporate or an individual or a partnership, and that kind of a tax rate would apply. So the foreign exchange protection has to be taken care. The hedging has to be taken care.
The next question. Imran Rashid is a proprietor of a firm, and he has started this venture 2 years back and has also been doing the operation. He has also opened a proprietership account but has not registered anywhere. He wants to know should he register his firm soon.
See, for a proprietorship, no registration is required anywhere. Okay. So if you start up a proprietorship, then that name and style in which you do your business, it is actually your own business, and the entire returns, I'm sure he must have filed with his income tax returns, and that is sufficient. If in the 2-3 years time, if he has done some kind of a branding for his business and developed some credibility, then he should use and go for a trademark registration of that, because that would protect his goodwill interests in future. Apart from that, no registration for a proprietorship is mandated till now.
Navi Arora wants to start a company in 2 different niches. One of them is IT services and the other is jewelry trading. She wants to know, should she create 2 different entities for each, or can she do both kind of businesses as a single entity?
Yeah, one is IT and other is?
Jewelry trading.
Jewelry trading. Okay.
Yes.
See, if you no problem. In the if it is in the proprietorship format, then she can do both in the same thing. Nobody stops. In the partnership format, also both can be done in the same thing. In the company or the LLP format, the main objects would have to be drafted very well, saying that these are the 2 businesses which the company is willing to do. Okay. And once it is very clearly put there, the single entity is capable of doing both the businesses. For every separate business, there is no requirement of having separate entity. And the best example for this would be, you look at any bigger company, like say, ITC is having so many products. So it is not having separate companies necessarily for each. Similarly, Wipro or similarly Hindustan Unilever, right? But at the same time, from business, for her at this stage, I don't recommend opening many companies. But at a later stage, from business structuring point of view, like say for example, my business A has more liabilities and my business B has lesser liabilities, or I am more capable in running business B. For business A, I need more kind of a partners. So in that scenario, I would like to keep 2 businesses separate in 2 separate entities, so that one does not have any impact on the other. But as a startup, I don't find this a problem. It's allowed.
Kailash More is an NRI and he had a startup in the UK.
Yeah.
He would like to know if there are any legal procedures if he needs to start the same in India, same company in India with the same identity.
See, a foreign person in India can, a foreign entity outside in India, if they want to do business, they can either, establish a place of business in India, or they can make a subsidiary in India of that original entity, and or they can create an entirely new entity in India with a similar kind of a name by complying with the law. So all three options are available to him. He may choose either depending on his convenience.
The next question is from Rahul Banka. We'll be taking the last two questions for the day. The penultimate one is this one. He wants to know, is there any restriction in paying salaries to directors or shareholders of a private limited company? Can the tax department take a view that salary beyond the limit will be treated as dividend and chargeable to dividend tax?
See, under the current Companies Act 1956, right, the private limited company can pay any kind of an amount as the board takes a resolution to its directors, and it is between the company and the directors. Now, if what happens is, I have seen in some companies that the person A is drawing a full-time salary from company A private limited, also drawing a full-time salary from company B private limited, also drawing a salary from company C private limited. Now these are the issues which one has to legitimately answer in terms of the bona fide, and prove to the department concerned that you have not violated the law as per your convenience and you actually did the job. If somebody asks you, you need to prove that. Legally, you have all the rights to, in a private limited company, to draw any kind of a salary after complying with the board resolution, and if you comply with the shareholders resolution, that's also perfect. Shareholders as such cannot be given anything like salary. If any amount which is given to shareholders in any form, any manner whatsoever, the income tax section 222 considers that as dividend. So that is a very clear concept. Shareholders cannot be paid salaries as such. Directors in private limited companies can be paid as per the board resolution.
The final question of the day is from Sunil Bansal. He says that he's buying a software for his startup from a foreign company. Yeah. He wants to know what are the regulations involved in this process.
Yeah. See, for software there is no hard and fast regulation as such. Now you just need to once again just check that if you're paying in dollars, then you buy it to the proper channels, and you do the proper hedging, and the softwares which you buy, that is a call which you have to make sure that they are not having copyright violations of any kind of nature, or the patent violations of any kind of nature. So once you take care of these things, there is no restrictive role that you cannot buy this software. You are free to buy any kind of software.
Thank you very much, Deepak, for that interesting session. Thank you to all our attendees for participating in the webinar. We are glad that the questions kept coming.
I'll just put in the last two slides.
Yeah, sure. But due to a lack of time, we are unable to answer all of the questions. Please do send in your feedback and suggestions to us at eclub@nenglobal.org. Also, if you found the session interesting, tweet @NEN India. The recorded version of the webinar will be available at www.youtube.com/user/eclubNEN online by tomorrow. Also, join us for our next webinar on Building the A-Team by Mr. Sanjay Anandram on October 23rd, that is the next Wednesday, 3 to 4 p.m. We also have some free workshops lined up for you entrepreneurs. A workshop on getting to market in Delhi and Mumbai on 19th and 26th of October respectively, and one in Bangalore on understanding angel investment on October 19th. Thank you once again and have a nice evening.
Thank you.